Hey everyone, my jurisdiction is New Mexico, and I thought that the best way to start off whether or not the motion to dismiss would, if it would be granted or denied, was to first start off with definitions of assault and battery under New Mexico. So, first we have assault, and it consists of either an attempt to commit a battery upon the person of another, any unlawful act, threat, or menacing conduct which causes another person to reasonably believe that he is in danger of receiving an immediate battery, or the use of insulting language towards another, impugning his honor, delicacy, or reputation. And then battery is the unlawful intentional touching or application of force to the person of another when done in a rude, insolent, or angry manner. So basically, I think that we can easily say that Mark falls within these two definitions. He definitely committed assault and battery upon Jason. So I found this case by looking at assault and battery, and right here it says that it's a black letter law that causing an offensive touching, even indirectly, to another's clothing and not resulting in injury is the tort of battery. So we have that case. And then I went on over here and I typed in assault and consent up there in the search bar. And this is basically what I wound up clicking on. And I scrolled through here a good bit and I found both of these two cases. So this first one right here is Commonwealth versus Poro. And I scroll down, and right here, this case states, where the touching is physically harmful, consent is immaterial, but a non-harmful touching is a battery only if there is no consent. So basically what this is saying is that if the touching was physically harmful, which in our case, Mark wound up breaking Jason's jaw and knocking out his teeth, so I would say that it was harmful physically. Consent would be immaterial. So, regardless if consent was given or not, it doesn't even matter, according to this case. This case right here, Commonwealth versus Burke, goes a little bit further to add that in order to give consent, a person must obviously have the capacity to do so. So this ties in with the fact that they have been drinking, considering that they have been drinking, they were obviously intoxicated, so they wouldn't be in the proper capacity to even give consent. So, with these cases and those statutes, taking those into consideration, I believe that the court would likely deny the motion to dismiss Jason's claim, and Jason's claim remains viable. That Mark must go to trial because he committed assault and battery, and even though there was consent, it does it's immaterial because he actually hurt him doing so, and he was intoxicated. He wasn't in the proper capacity to even give consent, so that throws out the fact that consent was given anyways, according to this case.